right, folks, we are going to get started. This is the fourth, I think, application and implementation session. And I have the pleasure of introducing Ran, who's going to give an invited talk about cryptocurrency and policy.
Yeah, thank you. Yeah, well, it's a facetious title, but anyway, so I think when I was invited, they asked me to talk about my experiences with Fireblocks, which is a company which you'll hear about in a minute, but I'm a little bit advising too. Mostly they don't listen to me, but whatever. And so I started thinking about that and the work they've done there, but I think maybe it fits in a bigger picture. So I decided to give like a bigger talk. So what I'm going to talk about is like 3 different works that I was involved in, but there is a line, kind of like a thread that connects them about crypto and the real world, currencies, policy, and whatever. So and how to try to bridge things. So, and I think actually started maybe an answer to Yuda. Yuda yesterday, talk about how in the 90s when it started, the late mid 90s, if you were software, few people around, if you could read the definition, go through the effort, the pain, yeah.
Can we turn up the volume on the microphone or something?
Or maybe I will just stand near a microphone. Is this better?
Yeah.
Yeah. Okay. Good. Thanks. Sorry. So Yuda was lamenting. If you went through the hassle of reading through the definitions, then you could do MPC. So I'm going to say that. So my first encounter with MPC was spring of 1999. It's Benny Pincus here. So it was the class of my first semester undergraduate, graduate. 89. Yeah, 89. What did I say? I said something else? 89. No, sorry, 89. Yeah, sorry. And 89, very, very big difference. And there was the class, Oded Goldberg gave a crypto class, Introduction to Crypto, which Benny and I were students together there, and I stood next to nothing about what was going on there. It was really way, a lot of it way over my head. Later on, went back and understood stuff. But the main assignment was to do class notes, and Benny and I were together. We were assigned to do class note of the GMW2, the MPC class. And remember that actually we split the assignment. I was to do the Honors Materials part, and Benny was to do the compiler. And remember Oded, after the class, he gave I think Benny wasn't there that particular interaction. Gave me say, here's my personal copy of the GMW, and he started drawing on it, the back sketch. But I want you to do it, do the notes in a modular way. If you do the OT, here's the table for the function of the OT. So try to do it like this. So I says, I've been doing this assignment for the last 40 years or 30 years. So I'm trying to do it better and better. And also, little did I know, that for years after that, I was talking about the GMW, and people didn't understand what I was talking about. People were talking about GMW. I understand, but that's not the paper. Little did I realize that when he told me he has that his personal copy, he didn't mean that his personal copy. That's his personal version of the paper that only he wrote, and they're very different from what's in the proceedings. But this I realized only later. But it's actually much closer to what in the book and what we teach today is in the GMW. Proceedings is quite different. Anyway, so at the beginning there were no definitions, and actually, in fact, also from Yuda's talk yesterday. So my moment was, oh my God, they're using my definitions, and that was a moment for me. So started in around 2000, later on, yeah, and I was trying to do what Yuda was saying yesterday with some limited amount of success to correct bugs. So I just want to say that really definitions are really for me, and I think in general it's an ongoing quest to understand, and really understanding what's going on. It's really something to be refined, and every time I understand something new, and things I didn't understand before, what the formalin actually means and what it's wrong, but it's right. So it's a process. And always there's the issue of when you do a definition, what's find the sweet spot between the generality and the simplicity. And it's not always clear what the sweet spot, and not always people agree. Some people kept asking me, Shai was bugging me, why are you trying to do this more, to get to generality, why not to sweet generality to get simplicity? Always was this understanding, that notion, that feeling that if you do general enough, that would be simpler. And so I don't know. So people have different thoughts about that. But at some point, I was thinking, we try to do it as general as possible, and then maybe we can pare down after we know the extent of generality. And I think there are kind of simpler versions of UC, whatever the definition of security of protocols. But I think it's good to have something general to start from. That's for me. And the point is that one should let those definitions sit, and then issues come up. And in fact, I think in the last 10 years or so, maybe even more, I've been more like an editor of a document that is edited by many people, that people send me bugs on the publishing or private, etc. I think even one of the first people actually sent me a bug about my definition of the paper. This doesn't make sense. And of course, he was absolutely right. And I changed. But I think it's happened so many times later on. So I think, so first I think this UC thing is, I know maybe I'm rated there the author or the editor, but I think it's a joint community project with a lot of community knowledge there. That said, I also kind of want to apologize for all the pain and suffering that people have gone through when all the versions of definition, and the people are very polite, but I hear and I know. But I want but I think the point, but I want to say in the end is that actually I think now it's actually a stable state. So it's actually also already appeared, the JCM, but it's a formal thing. But I think more than that, it is in a stable state. And actually, I want to encourage people to look at the latest version, which is on the JCM thing. I think it's okay. It's no paywall, and things do change. So if you read, the UC at some point in time in the last 20 years, and that's what you have in your mind as UC, I think it's worthwhile to make the effort to read the current version, because there are differences, right? And it does make a difference. Just to make the point. Anyway, okay, so that's an aside, but that's not what I want to talk about. It's just a RAM session thing. Okay. But so I wanted to tell you about 3 stories about I know it meets the real world, but my experiences of how crypto meets the real world. And I already kind of like do the end in the beginning. The key takeaways are, so it's always the importance of keeping the big picture in mind, and not just look at the task at hand, and the importance of getting public trust, the design in the protocol, and thinking about public trust when you design the protocol. In particular, with zero knowledge proofs, the public is verifiable, and that will be a recurring thing. And it is important in our society, right, to have public trust. And if you haven't proven it publicly, then it wasn't done. And again, to know what's not important, but not to optimize for. It's not always what's easy to optimize, what you need to optimize. And of course, the importance of being proactive, not only in protocol, in proactive security, but in thinking and doing things ahead of time. So first 5 blocks. So they started, summer 2018. I get an email from a former student who wasn't even, my students for, masters or PT. We just took a crypto class, yeah, we want to do this startup. We want to do this, threshold signature for blockchains, and I was kind of, sure, but there are already things existing, and things known, and and nothing really new here. So what are you trying to do? But yeah, but we were, we still want to do it. The three people. One was it was him. He knew a bit of crypto, and there was another one who was knew from Checkpoint, system security. Another one had connections with the financial in the sector, and they thought they could do it. And they, if you can, help us in the protocol, and say, sure, but okay. And then it started, and then they thought which protocol to use. There's the DSA because that's what people use on whatever on blockchains, and what was out there. So and they wanted to have a very simple thing. Threshold is DSA, n out of n secure, whatever threshold. No, nothing fancy. And with the n is 3 or 5, and Dixon's protocol at the time, where there was H&R Goldfeather and Lindelof, talking about them, and Dorner and Shelat, and what to implement. So talk about in a bit more about they picked GG just because it was simple and you could actually do it. So exactly that line that the user showed yesterday, that you can actually do it without general proof, and it's okay. That worked for them, but it actually just underlines users' points, and I must say that I was not, it's not that I gave it, tons of thought, but it didn't jump to me either that there's whatever's lurking there. I mean, it was clear that this is just a sentence, but I didn't see a bug. Okay, so yeah. But then, okay, so they picked this and started implementing it, and on the side we started working on improved protocol, and it took some time, but we were working on the improved protocol. But let me tell you a little bit about the protocol, just at high level. I mean, there's a lot going on there, but I just want to make a point there. And so they were doing, so the point of doing this threshold DSA efficiently in both protocols are of similar flavor. I mean, you correct me if I'm completely mischaracterizing things, but or real, but so you start with the added sharing of the secret key X. The public key is G to the X, and you generate for each signature an additive sharing of some randomizer value K, which is an index from 1 through P or the group. And the point is that the trick is to use pre-encryption, the homomorphic property of pre-encryption, in order to generate together an additive sharing of X times K, right? And that's kind of the tricky part that requires interaction. And then from there on, generating the actual signature is an easy sale, just linear stuff. So really the challenge is how to do the pre or the multiplication. So the challenges here, once after you do the basic protocol, is that parties need to prove to each other do things correctly. So what exactly do you need to prove, and to whom, and what is sufficient necessary? This is exactly all those issues that affect the efficiency, and how to do security analysis, right? And I mean us doing the analysis of the protocol, and those two protocols differ very much in the way they approached it. So Lindelof showed, like by the book, he showed that the protocol is a secure function evaluation of the ECDSA functionality, and you see, which is great. What else can you ask for? And GG did something else. They just showed us, they had the standalone game-based model, which should just show reduction from forgery in the protocol to forgery of normal ECDSA, which is great too, but it carries less guarantees. And well, neither work really addressed adaptive corruptions, let alone proactive. Adaptive is a requirement, pre-requirement, and in fact, at least in the Lindenhoff analysis, the adaptivity seemed to be
full adaptive, not proactive. The proactive is equal, adaptive, right?
no, but proactive is adaptive, right? Okay. Well, okay, never mind. Yeah, okay, you can do it. Yeah, I know people do it, but yeah. But that maybe that we can take it offline. But that's proactive without proactive static really meaning. But whatever. Say it again.
Each refresh protocol.
Each, but the adversary who is refreshing. But you have to, if you are static proactive, you have to decide ahead of time who you're going to rapidly reach.
Beginning of each epoch, you decide who's proactive. You don't do it there.
You don't have to decide ahead of time for all epochs? I'm not sure. Okay, well, let's say, okay, never mind. Let's say offline. Okay, yeah, well, yeah, okay, good. Yeah, okay, so anyway, so but definitely adaptive corruptions, and well, at least for me, I thought that never mind, that you need to adapt to be proactive to begin with, and it's especially for the Lindenhoff, the UC analysis, it seems inherent because you have to simulate, and the simulator doesn't know the secret key. So when you simulate it, at least one of the parties has a fake, whatever the fake, it's the fakes its actions, and when that party actually gets corrupted, the simulator doesn't know how to open. And it's kind of like inevitable that this will be the case. So it seems to be kind of dead on the spot, and somehow this particular issue didn't seem to happen in the GG protocol. So then we came up with this idea that we can actually get the best of both worlds. So maybe doing secure SFE is too strong, and you can still do something meaningful in the UC way. So what we did, we wrote an ideal threshold signature functionality. There was already signature functionality, so made it a threshold one in the UC, and we showed how to realize it in the UC model. And then we could do these things with adaptive security. And the reason that we could do it with adaptive security is that, well, on a high level, is that signature is something that only requires correctness. There's no secrecy guarantee, so somehow the simulator that you can know all the secrets in the simulation. Only need to show that forgery doesn't happen. So the adaptive security doesn't come up in the simulation in the actual simulation in the UC framework. But of course, it has to come up somewhere. And the catch is that it comes up when you try to show that really that the really the same is the ideal, that the environment can distinguish. And there you have to show that the environment can distinguish, then you can actually break the the underlying DCDSA. But then the environment is just a machine, right? It's people say it's just on your lap. You can do whatever you want to it. In particular, you can rewind it, and that's why you can actually do this adaptive security, because you really get the probability 1 out of n that the environment corrupts a party that you don't know how to simulate in the reduction, but then you can rewind and try it. So it's kind of like a way to get kind of the best of both worlds, and the really is to to find the way through. But I think more generally the philosophy, the idea is if you can prove something definitely secure, maybe you can don't give up on adaptive security. Try to see whether you can prove something slightly weaker that is still good enough and will be adaptive secure, and try to relax what you want to go to. And so sometimes you can't, right? Because as Nielsen, as Jesper says, sometimes there's actually possibilities. But anyway, so actually the protocol has many more improvements, but efficiency improvements. But I think this was the starting point, and really once this was in place, all the other improvements kind of came in naturally. So in the end result was a protocol that was actually good in many respects. So there was proactive and adaptive and UC, and there was also a non-interactive signing. There was a pre-processing phase and signing phase, and end-of-end security, and good ground complexity, and even and the definable aborted, whatever. So, and in the end, the protocol. There was a protocol with Nikos Maniakis and Udi Pellet from Fireblocks, and then we joined with merged with Rosario and Steven. So that's with the protocol, and there is a comparison of numbers, but never mind. That's not my point. But back to Fireblocks. So where I started out there, I stopped earlier, right? So we worked with the full protocol, and the protocol actually implemented and quickly became like the main workhorse of Fireblocks. And all those bugs that were, vulnerabilities that were discovered, actually helped make it quicker. And whatever, Fireblocks knew about it a bit earlier, but whatever, never mind. So, but it really makes things go faster. And then the company really became insanely successful, right? It's like, I'm still amazed, so like there's already, those special things are already assigned more than $1 trillion in transactions. And there are like much more than 1,000 institutional customers. And the company is valued now with this crazy amount of $8 billion. I know it's all money in the air, but still, it's really crazy. And I know the question, asking myself, why, where did success come from? So maybe the bottom bullet is the important thing. I don't think that data security, UC security MPC is what made it, right? So it's not that. So there's very little to do with this. Well, maybe given some bragging rights, right? But you think differently, say.
It was their UI and a very, very simple idea of keeping friendly, human readable addresses.
Yeah.
Public keys.
Yeah.
Really great user experience. Maybe that's what we might have.
Yeah, that's So right, yeah. So right. So I think the point, what made it successful was that they kept it simple and focused. They didn't try to do the most fancy things, and maybe they did well by ignoring my advice, because I always try to push them to do more fancy things. And I mean, they were very polite, thank you, but yeah. And they went for institutional customers, and they talked with regulators. Which you have to if you want to talk to do institutional customers, and that's important. And actually, I'm going to go back to this regulators point in the end of my talk. I think it's a key point. And actually, another thing, they played well this shared custody feature. The same concept actually that was touted from the very early papers of threshold signatures, but they actually, it's not because they read them, but they were just playing it to customers, so there is shared custody, right? So the Fireblocks does not have custody on the money. Fireblocks cannot steal the money even if they want to. So of course, Fireblocks writes all the code, so that's maybe you can another way, but at least cryptographically cannot steal the money. And in addition, the customer does not worry about incompetence of employees. So this really, the shared custody is what made it attractive, as far as I heard from the Fireblocks people, to those institutional customers. And then once in those institutional stuff, once it becomes kind of like a standard, then everybody does it, right? Because everybody does. So I think that's part of it. Anyway, so that's one story. Let me, yeah.
Just personal comment about it. At least from my personal perspective, one thing that's important to being successful is to do a serious work. And this, I'm saying, I personally talked to several custody providers like that. These guys impressed me as they thought through the process and thought about various different attacks. Other companies that offers comparable services, it was obvious that they have no idea. So I mean, if you're going to do a company, make sure that you do serious job on this. Is the point there.
Right, and I think maybe this goes with being simple and focused, right? If you do too many things, that you're not going to be, right? Yeah, going to be that, right? Good, thanks. Yeah. but okay, so let me go switch gears to a completely different topic. So we'll talk about Apple's CSAM scanning proposal. I know how many people here are familiar with that. Let me do a quick overview, a quick recap. So the Apple has this Apple Cloud where users store their photos, and they have always wanted to have key management so that only the user have access to the photos, and that Apple has no way to access the photos if the user doesn't agree. And unlike other clouds, they've been wanting to do it for a long time, and one of the things that prevented them from doing it is this CSAM scanning. So CSAM is the sort of a child sexual abuse material that is in the US is highly illegal. I'm sure in Europe too. I don't know the European law, but I'm sure it is too. So in US, it's unlawful to own one under any condition, and not for research, not for nothing, only law enforcement, and even there it's very restricted. And still, of course, people trade it, and most permanently create it and then trade it. There is the law enforcement effort to keep that to catch violators, and law enforcement requires companies to do scanning of customer photos, and this is what. But nobody said it explicitly, but that's the understanding, that this is what prevents Apple from doing it so that the user is the only one with the key. And they wanted to do it. So they came up with a protocol. Okay, so let's say what's going on now. So all the users put their picture in the cloud, and the law enforcement goes with images, target images that they collect, and then Apple goes and checks with the clouds. But what they wanted to do is the protocol which has the customers or the phones still have the key. Apple doesn't have the key to go check the pictures stored, but there would be a private section protocol where Apple will give the target images, and the phones will locally compute the hashed, it's going to be hashed images, this special whatever semantic hash, never mind that. And the protocol will check if there is enough matches, which is going to be fuzzy, and it's going to be a threshold. If this is the case, the protocol will as part of the protocol, the phone will give the key to the pictures to Apple, and then Apple will go to the cloud and take the pictures and decrypt, and send it to law enforcement to continue whatever investigation. So it looks like a great solution, right? Cryptographic solution that to a problem that will allow phones to have keys. Exactly what you would want. So they came up with it. In fact, they came up with it. They did this right. Furthermore, they actually had serious cryptographers design it, and in fact, more additional serious cryptographers analyze it and write reviews on it. And I think some are here. So they really seem to have done a serious job in doing it. But as soon as it came out, there was a barrage of terrible comments, terrible reviews from all spectrums, from techies, from non-techies, from privacy people, from all, so never mind, there was a whole barrage of discontent and complaints, and it was it is actually, I was reading through it and I was surprised what's going on there. I mean, what's the point? Why is everybody so up in arms against this thing? Which seems that they did an honest job, including cryptographers and of course non-cryptographers and lawyers and this and that from all sides. So I think it's at some point we realized that Gabe Kapchuk and I were talking about it a lot, that there's actually they missed one big issue, which is public verifiability. because the way the protocol is designed is so easy to Apple to abuse the system, right? So nobody checks that Apple is really what are the hashes that is checking the entering the PSI. It can be, if I'm Apple worker and I want to see if you're looking at my sister's pictures, I can put my sister's pictures there and see if it comes up, right? Or something else, right? And of course, difficult to detect catastrophic failures, systematic failures, because everything is done undercover. And the security analysis in general hides the societal aspects, right? And exactly the same thing happens if you think about the enforcement side. We like to trust law enforcement, but also there it's easy to abuse and it's easy to detect failures, and you don't think about societal aspects, right? And I think this is what was going on there. That was the reason for all these all the complaints. And really, even though there was this very nice cryptographic proof that the cell intersection protocol really is secure, there was two different proofs, game-based and explanation-based written and stuff, but they're all right. I'm sure it's right, and it's actually I know I read them, but really doesn't mean much to society, right? So the point is that if you think of the big picture of what's going on there, so there's a whole big system, right? So there's the physical world where the pictures getting generated, the law enforcement that gets them. There's NCMEC, this entity that's collecting these pictures. Actually, also there should be an error directly for the physical world for NCMEC. Never mind. NCMEC is an agency which is not really government agency in the US. It's kind of non-for-profit, but it's funded by the Congress, but it's not police. And then it gives the hashes to Apple, and then Apple does the private sector section, and there's all these things going on. But the only thing that the analysis was taken into consideration was this, so just what's in the red, and completely ignoring the rest. And this is I think the reason to the disconnect between Apple and the cryptographers that worked on it and the rest of the world. So you can think about bigger, try to make it bigger and bigger. So maybe you want to do things like prove that that really the hashes correspond to images that contain system context, right? So you can think about ways in order to make this like a bigger analysis in a more secure protocol. So for instance, you can say, I think I missed the slide, but anyway, so there was so Gabe and I wrote a blog post about it. It actually got quite a bit of traction, and the point there was that the need for public verifiability. And you need to have public verifiability, actually more than public verifiability. You need to have verifiability in the process, right? So the client, at the time that it does the protocol with Apple, before it actually gives the keys to Apple, the client has to be able to verify locally that those hashes the Apple contributes is actually coming real hashes, right? Real system hashes, not something made up. That's one thing. And then in addition to that, the public has to be able to verify that the system is working correctly. That really all those, whenever there is something that's happening, that a phone that is being discloses pictures to law enforcement, it's because there's a chain of custody that shows how there's really because of bad hashes. Right. And that's something that can be done. We know we have NISX, we can do things with publicly verifiable, so why not do it? And you can do it on a number of different levels. So that was the suggestion. And this is, in fact, the suggestion, this is actually something that we have been implementing, and that's kind of work in progress, but that's something that is going to come out soon, is that the same protocol, start from that protocol and add NISX to it to do verification, public verifiability. And the point is that to show, it's a proof of concept, right? But just to show that it can be done, it's not too complicated. so that and hopefully it will make an impact. Not for you guys. I don't need to do it in order to convince you that it's doable. It's not too hard, but I think for the rest of the world, maybe one needs to do it. So we're trying to do it to show it. So this is kind of like the parts of the protocol. So you need to commit to the hashes, and you need to do a NISIC at the time of the protocol execution, and you want to actually also have some proofs that those hashes that are committed by Apple that are used in the protocol actually came from a legitimate source like NCMEC, so they are either signed by NCMEC or whatever, and so they can again commit to the images and they can sign them, and then you can actually, that's something that we didn't do, but something that you could do is actually do another step level and actually do the NCMEC itself. Instead of just signing this comes from us, NCMEC can actually publicly prove to the world the process by which it picks pictures. So it's not that just somebody in NCMEC decided this is a CSAM picture, but actually there is a process. And that's something that can be done. And again, that's just to be made part of the workflow. So that is the idea. We did part of it, but there's much more to do. Okay, so that's number 2, and I don't have much time, but let me just say a few words about number 3. So this is work. It's actually part of a bigger work that tries to find applications of zero knowledge in the legal system. So this is going to be specific to the U.S. legal system, but I think it has some more general lessons. So can technological feasibility and particular zero knowledge affect existing legal doctrines? So what am I talking about? What am I saying? So this, I don't know if there's any lawyer in the room, but I can bullshit whatever I want. But let me try to explain. So this is based on 2 works that I've done together with with law people. Especially that's really important to work with law people if you want to have an impact on law. So let me start with a little story. So there is this case of US versus Budziak. So there was okay. So maybe I'm trying to think. Okay, let's do it. So FBI used a modified version of a peer-to-peer network called LimeWire. It was 2007 and 8 to actually target people that share CSAM on those on this peer-to-peer network, and they found CSAM on actually they found that the computer of this Budziak sending CSAM on this peer-to-peer network, and they went and did a search and they found more CSAM in search. And then defendant actually claimed that no, I didn't share those CSAM on peer-to-peer network. They were only for my own use. So just to say there's a big difference between CSAM for own use and sharing CSAM is very, between 5 years and 20 years or something. So it's a very big difference. And he wanted to see the software that the law enforcement use in order to see the files that law enforcement claimed that he shared in the law enforcement graph, to see there are no bugs in it, and actually he had some specific claims about what things could go wrong, which kind of made sense. And in prosecution, the law enforcement argued that allowing the defendant to see the software will kill the efficacy of the software to future criminals. And there's a clause in US law, the law enforcement privilege, that allows under some conditions to withhold evidence from defendant in such cases. So there is a whole set of things that you have to satisfy. And in that particular case, the judge decided that this holds and actually allowed a law enforcement to not show the software and still have the evidence be considered. This all proceedings happen before the actual trial starts, the pre-trial, before the jury comes in. But then, so the trial happened, and the evidence was used, and of course the person was found guilty based on this evidence. And then the defendant appealed, and whatever some appellate circuit actually determined the defendant had the right to see the software because of due process rights of defendants to see the evidence against them. And he ordered the FBI to disclose the software. And then the funny thing, actually, I want to say before the funny thing is that actually I wanted to read from the writing of the judge on this case. Oops, anyway. So a party seeking to impeach the reliability of computer evidence should have sufficient opportunity to ascertain by pretrial discovery whether both the machine and those who supply it with data, input, and information have performed the task accurately. And then another one, it's quite incomprehensible that the prosecution should tender a witness to state the result of computer's operation without having the program available for defense scrutiny to use in cross-examination. So really something that for us sounds, of course, but it's actually important that it's written by a judge. So anyway, the bottom line is that when this happened, the FBI were unable to find the software. It was already 3 years after, whatever, it was written by some contractor, it was no longer there. You read it, it's really ridiculous. Anyway, the case for this week, the person was set free. We don't know if they, clearly the legal system failed, right? On many levels. We don't know, maybe the person was a criminal, should have stayed in court, maybe he wasn't, but anyway, there's no good feeling about the legal system, right? And things, like that, this is just one example, there are many other examples like that, right? So the problem, again, just to say it again quickly, it's, so people do bad things, law enforcement do some software to catch them. Software has to be hidden, to be effective, and then, nice drawing. But then comes court, and then the defendant wants to see the software, right? And then law enforcement said, no, you cannot see it because it's hidden. And then, trust me, it's okay. Actually, there are affidavits of policemen saying exactly that. And then, of course, the person doesn't trust, and then what do you do? There are specific complaints always in different cases, different specific complaints. So there are two, competing rights, right? And each one of them is a right which has value, right? So the defendant has the right to see the evidence against them, but society, law enforcement has the right to keep things, secret because we want to have, we want to catch criminals, right? So, so what do you do? So, and there's, judges that say that exactly those words, there's a conundrum, what am I supposed to do? Essentially, that's what the judge says. So right now, in the legal system, there are three options. So the judge can either order disclosure of the software, and then it risks, harming law enforcement. Sometimes law enforcement will just refuse to disclose it and will prefer to let go of the charges rather than disclose the software. This has happened many, many times. And then you have the possibility the criminals go free, or it actually can what they just did before, not allow the defendant to see it, and then you lose all grounds of due process, which is like the basic grounds of open court system in democracy, right? That's really unacceptable. Or sometimes they have expert witnesses that go and there will be somebody that's trusted by both parties that checks and says blah, blah, blah. And this sometimes happens. In fact, we tested some cases where it happens, but even that goes wrong pretty badly because you can see the questions stated to the expert witness, in legalese and about technical points, and it completely misses the mark. And there was actually a case that I don't have time to describe, but another case where they actually went for a third-party expert, but the questions were written in such a bad way that a biggest way that the whole thing was mangled, and then the person in the end, the person just they settled on something which didn't make sense. So it's clearly, again, the legal system failed as a system. So anyway, never mind the details. So the point is that we are saying maybe zero knowledge proofs can help here, right? It sounds like a good place for zero knowledge. So we try to that work was actually to try to first it's write the legal underpinnings for how to use zero knowledge in a court system like that, something that the legal people can understand, and then we actually did some very simple implementation of something that answered specific questions in actually this Woodja case that I started from. Okay, so there's the story. I'm not going to go through that because I don't have time, but that's the other guy, the Clement, that tried to find to do express witness. So what's the story with this peer-to-peer software? So peer-to-peer software, we share files, but we don't we don't get a file from one specific person. We get pieces of a file, each one from a different person. That's not good for enforcement. In order to show that that person shared the CSAM, they need to get all the pieces of a file from that particular person. So they have to mess with the underlying peer-to-peer system to cause the computer of that target person to send all the pieces of the file to them. And that's how they may have to mess up with the system, and they actually have to do some more because the systems have those credit things that you can download if you don't share, but then law enforcement cannot, so that's vote, cannot share CSAM itself. So they have to do all kinds of things in order to get around the protections of the systems in order to actually get evidence. So I'm putting aside the issue of the ethical issues, whether it's okay for law enforcement to do those things. What we're trying to prove here, to help law enforcement prove in zero knowledge that its software only did that. It only messed up with those things that I said right now, other than doing other stuff that defendants claim the law enforcement is doing. Because there are actually exploits for peer-to-peer systems that do other things. For instance, there have been known exploits that surreptitiously turn the sharing bit files on somebody's system from non-share to share, just because they want. For the peer-to-peer system has wants people to share, otherwise it doesn't work. So they do this also. They actually turn out things to share. Yeah, I know we're running out of time. Anyway, so we did this, and so what I want to say is that to jump through. So there's a process that we wrote. Just a second. I want to show one slide. Yes. So there's a process that we wrote on how to use a zero knowledge proof in a legal system. So first, law enforcement comes in with a predicate, and then the defendant see the predicate is okay. Maybe they go back and forth and adjudicate before the judge, like they would do in a normal way, but in a much more fine-grained way. They can actually talk about different properties of the program that they want to verify, and then once they agree, then you run the zero knowledge, the snark, snark on the software, and then you get proof that's supposed to verify. And the point here is that what will make it work is to actually understand what it is to prove and what not to prove. And because if you start doing things like law enforcement is completely malicious adversary and you want to prove everything, it soon becomes intractable, right? Because who says that the program that the law enforcement showed you or even enters as zero knowledge is the program going to be used? And who said that the change of custody of this file is the claim? So, but if you go there, there's it's a rabbit hole. But those things you don't need to, because anyway, you have to trust law enforcement for something. You also trust chain of custody of a gun. They show this is a gun that was used, in the murder scene. But so you want to do other stuff. So that's what we did. And in fact, we did it and we implemented it. We suffered a lot implemented in Cairo, but I think it was the wrong tool to use. Should be better tools, but never mind that. I think the most important point that I want to say here before the conclusion is that the legal argument that part in the protocol, that the very fact that this exists, even though it's not used, the very fact that it exists and it's feasible should make a difference in court decisions in the future. Because part of the process in the court to decide is, decide whether to give law enforcement privilege or not, is whether law enforcement did everything that is technologically possible to disclose to defendants, right? So the very fact that this is possible puts an onus on law enforcement in the future. At least that's what claim the paper, which will happen, we'll see. But I know. So it means the legal, Rebecca, which is the lawyer in the paper. Anyway, so I'm really running out of time, but I wanted to say, actually, I wanted to say something in the end about regulation. So sorry for taking more time, but I think it's important. So the need to embrace regulation. So going back to cryptocurrencies. So I think we should remember, regulators are our friends, they're not our foes, and they have legitimacy. They really enable a smooth connection with fiat world, with cryptocurrencies, and they make that the whole point is to make the decentralized space less of a jungle, more regulated, more normal, and so we want to work with them, and we need to be proactive because we are the ones who understand the technology and can come up with the right solutions that do the right balance between privacy and regulation. And they are really open to industry-led regulations. There is notion of a travel rule for money. People in the industry probably know. It's something that regulators let the industry decide what will be the travel rules for money. And it's important that the industry does it right. Because if we don't do it right, either they do it for us or they not do it at all. And either way, it's bad. So, and actually, I recommend watch the talk by Shlomit Wagman. She was the chief, cryptocurrency police officer in Israel. The one that is a regulator of cryptocurrencies and anti-terrorism money. And she finished a job a couple months ago. She gave a talk at the Berkman Center. It's very interesting to hear. She's right on, and so we should work with them. And what can we do? And we can make it easy to store logs in zero knowledge accumulators, and maybe with daily posts and prove zero knowledge statements on those logs, and make it standard to accompany any MPC that we do, any of the MPCs that we talked about the last 3 days, to do it with publicly verifiable proof that's what is done, right? So I think it's really important to make it a standard, right? If there is no proof online, it didn't happen. Like in pictures, right? Today, if you didn't take a selfie, you weren't there. So same thing. And we should create a language for discussing with regulators, and then specifying what needs to be asserted and then doing it. So I think it's an important process and we should engage in it. We should lead it, not be led. That's it. Thank you.
Right. Maybe one question while the next speaker sets up. Any questions?
You said that there would be commitments to hashes and the apples.
Yeah.
So then now the user has to check the commitments, then is it verifies, and the statement itself seems to be the size of the entire database.
So the statement would be that so there would be commitments, a NICMAC would post commitments of the hashes, and what the proof would be that those hashes that Apple ends as the protocol are hashes that were generated by NICMAC and signed by NICMAC. Yeah.